Are you Greg S. Martin appearing there from the jail?
Yes, sir.
All right. This is case number 25 CR 95, State of Ohio versus Gregory Scott Martin. Mr. Martin is appearing by Zoom from the jail. The video system we have is down, and Mr. Wagner is also present on behalf of the defendant. And I believe, did you represent him at the municipal court level, or are you standing in for Denny on this one?
I think I'm filling in for Mr. Kirk, Your Honor. The name does not sound familiar. I may have, but I believe I'm filling in. I'll take the appointment either way, though, if you want, Your Honor.
Miss Barger actually represented him before.
Oh, Miss Barger did? Oh, okay. All right. For some reason, I think prelim says Kirk on the arraignment sheet. I don't have my arraignment sheet. Do you have one?
Your Honor, may I address the court?
Sure.
The prosecutor's office informed me that I believe this gentleman has a pending felony that Mr. Kirk already represents him on.
Okay, that's it. Okay, that's it. All right, thank you. I knew that we had looked at that for some reason. All right. All right, so Mr. Kirk will be appointed to represent the defendant, but he would stand in for him for this arraignment purpose.
Gladly, sir.
Because Mr. Kirk is on vacation. And since Mr. Martin was indicted, I wanted to get this case on the docket. So, Mr. Martin, you are charged with burglary, second-degree felony, and that carries a possible minimum sentence of 2 to 8 years and a maximum of an additional 1/2 added on to whatever that minimum sentence is set, and a fine of $15,000. Grand theft, a third-degree felony, and it carries a possible prison term between 9 and 36 months. Fine of $10,000. Safe cracking, a fourth-degree felony, carries a possible prison term between 6 and 18 months, and a fine of $5,000. And there's a request for a forfeiture of a Yamaha Rhino UTV, allegedly used in commission of one or more of those offenses. Offenses are alleged to have occurred on about May 15, 2025 in this county. Count 1 alleges you did by force, stealth, or deception trespass in a home at 3700 Alexander Lane with purpose to commit therein a theft offense. It was a temporary or permanent habitation of a V who was either present or likely to be present. You had a purpose to commit a criminal offense. Count 2 alleged on about the same date, time, and place. You did knowingly obtain or exert control over several firearms belonging to V without their consent. Count 3 alleges that on about the same date and time you did with purpose to commit offense knowingly enter, force, and entrance into, tamper the vault, safe, or strong box. All right. So the court has reviewed. Is everything on your financial statement correct, Mr. Martin?
Yes, sir.
All right. All right. Well, the court then will, as I said, appoint Mr. Kirk to represent you, and Mr. Wagner is standing in for him for purposes of bond and arraignment, and the plea is not guilty.
Not guilty, sir. I apologize. Yes, Your Honor.
All right.
That is his final pretrial. If you want to set
Oh, good. Thank you. Thank you. Appreciate that. Ms. Kirk, or I should say Ms. Collins is on behalf of the state appearing by Zoom. Mr. Wagner has previously indicated he's present in the courtroom. I neglected to ask Ms. Collins, has the alleged victim of the offense has been notified of the time, place, and purpose of this hearing, the right to be heard?
They have, and they will not be present at the arraignment.
All right, thank you. All right. The court will set the first pretrial hearing for this charge on July the 16th at 1 p.m. The final pretrial will be set for August the 6th. At 1 p.m. Trial date will be set for August the 11th, which is the speedy trial deadline. That will be subject to change, Mr. Martin, if your attorney needs additional time or if you do to prepare for the hearing. All right. Ms. Collins, anything from the state regarding the matter of bond?
Just the recommendation that's contained on the bond notice, Your Honor. And we would note that the defendant has an extensive prior criminal history, as well as a case that's currently pending.
Is he on bond on the other case?
I'm not sure what his bond is on the other case.
All right, Mr. Wagner.
Respectfully, Your Honor, again, I don't know this client. He's Mr. Kirch, but it's my understanding he's being held on the current case, not the one we're being arraigned on today. So I'm not sure me arguing for bond is actually relevant. I would ask the court to set a reasonable bond, but again, I think he's being held on the other case as well, sir.
All right. The court will set bond the amount of $25,000 plus OR, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony if convicted. Sentence on that, no matter what happens in this case, you'll be under the same pretrial conditions as your previous case, including house arrest, if you do make bond. All right. Thank you.
Excuse me.
Thank you. All of that. Myers.
All right, this is case number 25, CR96, State of Ohio versus YFT Meyers. Are you YFT Meyers appearing there from the jail?
Yeah.
All right, this is an arraignment on an indictment for rape. The state's represented by Prosecuting Attorney Collins. Ms. Collins, has the alleged victim or representative of the victim, alleged victim, been notified of the time, place, and purpose of this hearing and the right to be heard?
We attempted to make contact, Your Honor, just didn't have a lot of time. We had to leave a message.
All right. All right. And Mr. Meyers, you are entitled to have counsel to represent you in this matter. And if you don't have the money to hire one, the court will appoint one for you. Do we have a, oh, here it is. Okay, I see you did fill out a financial disclosure form. Everything on this correct?
Yeah.
All right. The court will find that you're entitled to appointed counsel. I'm going to appoint Mr. Jacob Wagner to represent you, who is present in the courtroom for another hearing. So, and I believe you handled the preliminary on this case.
Sounds correct, sir.
All right, all right.
We waive any reading of the indictment.
Waive the reading of the indictment. All right.
Enter not guilty, sir.
Okay.
Apologize, Your Honor. I got ahead of it.
All right. Let's see here. Court will set the first case in this in the first pretrial in this case for July the 16th at 1 p.m. Final pretrial will be August the 6th at 1 p.m. and trial will be set for August the 14th at 1 p.m. I'm sorry, 8 a.m. Thank you. All right. Ms. Collins, State wish to be heard on the matter of bond.
Your Honor, we would request the court issue or set the bond at $100,000. We would note the serious nature of this charge. Additionally, the relationship between the defendant and the victim facilitated this offense. And finally, there is a serious fear of retaliation based on, alleged at this time, threats that were made against the victim should they disclose what had taken place.
Mr. Wagner?
Your Honor, we simply ask the court for any reduction in the bond whatsoever. I do respect the serious nature of the offense. Hopefully sometime this weekend I can get out and talk to my client, find out more about his financial situation.
All right. Bond will be set in the amount of $100,000 plus your own recognizance, which is your promise to appear, Mr. Myers. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll be under pretrial supervision of the probation department if you should make bond. And you'll report to them at 117 East Main Street immediately upon your release, once a week for 4 weeks, and after that, as they determine, you'll be required to undergo random drug testing as ordered by probation, provide phone numbers for home, cell, and employer, have no contact with alleged victim or family members. If recommended by probation, be evaluated for substance abuse or mental health issues or any treatments indicated. You're to roll in and follow that during the pendency of this action. You'll also be under a house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational programming of any sort, and church services. Other than that, you have to be there at all times. And if you fail to comply, then that bond can be revoked to be held till further order of the court. All right, is there anything further from counsel?
No, Your Honor, thank you.
All right, thank you. Are we using the same link for later? Case number 25 CR 48, State of Ohio versus Christine E. Kennson. Present for the State's Assistant Prosecuting Attorney King. Present for the defendant is Attorney Jacob Wagner. Are you Christine E. Kennson?
Yes, sir.
Right. Ms. Kennson has entered pleas of guilty to counts 4, 6, and 9 of the indictment, all aggravated trafficking and methamphetamine, third-degree felonies. The court referred the matter for a pre-sentence report. I have received that and reviewed that of each of the attorneys, an opportunity to review a summary.
The State has your number.
We have, sir.
Great. Anything from the State regarding sentencing?
Thank you, Your Honor. The State would just ask that the court follow the joint recommendation in this case.
There is restitution to the task force in the amount of $1,130. That's all they do.
1,175.
1,130.
Oh, 130. Okay. Mr. Wagner.
Yes, sir, Your Honor. Stand up, Christine. Your Honor, we would ask the court to file the recommendation, and I had something planned, and I kind of reshuffled that, and I told my client I would not ask you for this, but after talking to her counselor and seeing her today, I'm eating my own words. I know you never delay sentencing, Your Honor. You want it like that, and I told my client last night, we were texting about 7 o'clock, to be ready. Met her counselor outside today, and again, I'm asking you to follow the recommendation, Your Honor, but she's about 30 days away from graduation. August 16th, give or take, will be her graduation. She's been down at Cardinal Treatment since April. I can honestly say the woman here before me today is nowhere near the lady that came into my office when this indictment started. And I mean this respectfully, Christine. Speaking in my language, she was a hot mess when she was in my office. She wouldn't shut up. She babbled, she cried, she was incoherent. Now I see her today, this is not the same woman. I mean, this is awesome. To those guys, thank you so much. I know you don't, Judge. I told her to be ready, pack a toothbrush. You're going today. If there was ever an exception, Your Honor, I would ask you to do it on this one. She'll report however you order, but I think she's set to go to transition. I know you want her to go to, she'll have to go to prison. We get it. I would just I think it would be beneficial for her to graduate instead of restarting everything, Your Honor. But again, I'm well aware of your policy, how you typically do it, and Christine's well aware of that as well. But again, I give her congratulations and cardinal treatment. This is a different woman in front of you today, Judge. But that's it, sir.
All right. Well, the court is going to proceed with sentencing. I know that she's in treatment, but given the nature of these offenses, the recommendation for a significant amount of time, there is a consideration of state non-opposing judicial release after 6 months. If that is granted, it would obviously involve a course of treatment that would take place. So I don't really think that the issue of graduation is all that significant in terms of the overall view of the case. So the court will proceed with sentencing. Anything else you'd like to say, Mr. Wagner?
None on my behalf, sir.
Ms. Kennison, anything you'd like to say?
I just want to apologize for my actions. I'm an adult, and I was going through a lot of grief at the time. I lost my husband of 27 years, and I wasn't making clear decisions. And I am accountable for those decisions today. And I probably wouldn't be alive if I didn't be held accountable and come here today. So I do respectfully apologize for my behaviors.
All right, it is the order of the court that the defendant be and is hereby sentenced to the Ohio State Reformatory for Women at Marysville, Ohio, on count 4 to a term of 12 months, on count 6 to a term of 18 months, and on count 9 to a term of 24 months. Those sentences are ordered to be served consecutively to one another. Dan, the jail time credit minute. The court finds that the second sentences are appropriate because, first of all, there's a stipulation to that as far as the recommendation. Secondly, the defendant committed these three offenses as separate courses. Actually, one criminal undertaking, but over a period of one or more courses of conduct. The court further finds that one single sentence would not adequately reflect the seriousness of the crime, and that the sentences that are reimposed are in view of the overall possibility of 36 months in each count. Those are not disproportionate to the harm that is caused in the offense. Court further find that that's appropriate to protect the public based on the defendant's criminal history. I know you said that this was due to grief, but looking at your record, I see that your record goes back. You had an OVI in 2000, disorderly conduct 2004 and 12, domestic violence in 2011, I'm guessing at least one of the, or more of those, one or both of those disorderlies probably involved a fight. Then in 2015, theft, so you've had an ongoing criminal history. So, this isn't just some, off the wall, unexpected type of thing. And certainly you've graduated to much more serious criminal conduct, but it's one thing to be abusing drugs, using drugs, but it's another thing to be selling them, and particularly when you were selling in amounts that were enough to get you a mandatory prison sentence, which the state reduced in count 9 to allow you to avoid that. That is the order of the court. Now, upon completion of this prison term, if you serve the entire term, the Adult Parole Authority may put you under post-release control for a period of up to 2 years. If they do, you'll be supervised in the terms they set by the parole officer, and if during that period of time you violate any of those conditions, they can return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum of 1/2 of your prison term, which would be 27 months for more than one violation. However, if you're convicted of a new felony while under post-release control, then in addition, whatever sentence the judge in the new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You're also ordered to pay restitution to the task force in the amount of $1,130. That'll be payable through the Highland County Victim Witness Restitution Escrow account. You'll pay any service fees connected with that. You'll also be required to pay the court costs, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets. If that doesn't collect it upon completion of your prison term, not while you're in it, not while you're in prison, but once you're out of prison, you could be permitted to do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. The defendant is given 2 days of jail time credit. According to this, you were arrested on the 17th of March and released on the 18th. Is that correct, Ms. Kennson?
Yes, sir.
All right. Anything further from counsel?
Yes, sir.
No, sir.
See, there was a mandatory fine on these. Has there been any change in your financial circumstances since I appointed Mr. Wagner represents you? Oh, you're retained?
I was retained, Your Honor.
All right. Then
She sold her house.
all right. Well, if you'll have to file something to have a
And then she
mandatory
says-
fine waived, so you'll need to get an affidavit. So at this point, I'm going to impose a mandatory fine in each case of $5,000, subject to reconsideration if you do file an affidavit setting forth her financial inability to pay the fines.
Yes, sir, Your Honor.
Thank you. All right, you're remanded to custody.
Your Honor,
Yes.
I apologize. Just for my client, she was concerned the court, and I know you're aware, I know you mentioned it, that you'll consider judicial, or would you consider judicial when the time's appropriate, Your Honor? I think it's part of the...
Well, if she files, yes, I have to consider
Yes.
it.
She just...
I get what I'm saying is, if you want to know more. At this point, I see no reason why I would not, but again, it's not binding on the court, as I indicated, so
Yes.
I'll look at the time, and if I decide 6 months is too early, I may, as I usually do, will let counsel know that that's my thinking, so that the case is permitted to be withdrawn, so it's not prevented from being refiled.
Thank you, sir.
Yes, sir.
Okay? As long as you do what you're supposed to do, we'll be okay.
Case number 25-CR-16, State of Ohio versus David W. Everheart. Present on behalf of the state, Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Jacob Wagner. Are you David W. Everheart?
Yes, sir.
Mr. Everheart is under the plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. matter was referred to the probation department for a pre-trial, for a pre-sentence report. Also a referral to drug court. And I have reviewed the pre-sentence report of each of the attorneys. Had an opportunity to review a summary.
State has your own.
I have, sir.
All right. Mr. King, anything you'd like to offer on behalf of the state?
Only what is contained in the plea agreement, Your Honor.
Mr. Wagner?
Yes, sir. Your Honor, stand up, sir. Thank you. Your Honor, obviously, of course, I've inherited this case from Ms. Barber, so I wasn't part of the case from arraignment until today. I did speak to Ms. Sturgill yesterday, just trying to follow up on some of the details that I saw in this case. It's my understanding this was a drug court referral. Mr. Everheart, it's my understanding, is declining that, shall I say, invitation or opportunity. He indicates to me he is at Family Recovery Services here locally. So I guess I'd make the pitch, Your Honor, to put him on community control with the condition he complete successfully any counseling.
Mr. Everheart, anything that you would like to say?
No, sir.
All right, well, it is the court that you be sentenced to a period of 3 years of community control under these conditions. First of all, you obey all laws of all jurisdictions, conduct yourself in law, body, manner, on time. You report when and as directed, to be truthful in all statements you make to the probation department, as well as answers you give to questions they ask you. You must keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. Because of your conviction, you're now prohibited under both federal and state law from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordnance. To do so would be a felony under both federal and state law, for which you can be prosecuted and sentenced. It's also a condition not have any of those or any other weapons of any type while you're on community control. In this case, you're not permitted to purchase, possess, use, or have under your control any types of controlled substances, drug of abuse, CBD, or kratom, or any variant or analog of a controlled substance that has effects similar to those or drugs of abuse. Nor may you have or possess any instrument, device, or thing that may be used to administer drugs or prepare them to be administered unless you have a lawful prescription, and you must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as requested. If you're to purchase, possess, use, have under your control, you may not, and shall not purchase, possess, use, or have under your control any alcoholic beverage, nor may be present in places where the sold, being consumed, neither is otherwise lawful. You may not associate with anyone who has a criminal record, as a member of a gang or other criminal group, or any person who has in his past or could in the future influence you to commit a criminal offense and violate these conditions, unless that's approved in writing by your supervising officer, which would also apply to any family members that may fall within that definition unless you were living with them immediately before this offense was committed. You may not, after the date of this order, marry or establish a new cohabitation in a common law marriage type of relationship with another without written permission. You must report any charge of violating the law or any arrest, conviction, or citation not later than the next business day after that occurs. To provide your supervising officer with financial information so your ability to pay any fees or costs can be reviewed. If you're referred for an evaluation or assessment by the probation department for any type of treatment, therapy, counseling, training, or programming, you're to submit to that. If there's a recommendation for programming, you're to enroll in and follow that during dependency of this action. Pay the court costs and make payment arrangements to do that. Now, in reviewing your record, you have a pretty long record. Lots of disorderly conduct, violating protection order, FRA suspensions, DUSs, menacing by stalking, another violating protection order. So you, and then that was just the first page and a half. And then the next page, all kinds of charges, a lot of them dismissed, disorderlies, conviction, attempted assault, amended from domestic violence. This goes on for 20 years. You told probation that you don't use methamphetamine. You're convicted of methamphetamine, possession of it. You've tested positive for it twice, once at probation and once at the recovery council. You denied that you're using, although you do admit to marijuana. From your record, Mr. Everhart's parent, you seem to think that you're not going to be required to be held accountable for. You've been getting by with this stuff for years and years and years without significant accountability, in my view, of your record. And so it is the order of the court that you be required, as a condition of community control, to successfully complete the STAR program and any recommended aftercare. There is a bed available on July the 16th. You're remanded to custody, and you'll remain in custody of the jail until you're conveyed to STAR. Once they complete that program successfully, then you will be under aftercare, and you're to comply with that. Now, I can tell you right now, if you don't complete STAR, court, I've been judge for almost 17 years, and 100% of the time, if a person doesn't complete STAR, unless it's because of a health issue that they did not cause themselves. I had one idiot that pounded his fist into a block wall to break his hand, so because he thought that would be a medical reason. Well, he was wrong. He served his prison time with his broken hand. But you need an attitude adjustment. It's way overdue, and that's what this is. Now, by being placed on community control, if you don't successfully complete it, or probation feels that you've not completed it or not compliant, they'll file a motion with the court, and you'll get a copy of it. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is you haven't complied, then you can be sentenced to a term of between 6 and 12 months of incarceration and fined $2,500. If that should be to a prison sentence, then that could also involve post-release control for a period of up to 2 years at the option of parole authority. And if you violated their conditions, they could return you to prison to serve an additional period of up to 1/2 of the prison term that's imposed. But if you're convicted of a new felony, then you could be sentenced to an additional period of 1 year or whatever time's left on that period, whichever is greater, and that would be were to be served consecutively, the sentence in the new case. You're also deemed to have consented to a search without a warrant of your person, vehicles owned by you, used by you, or any other property or place where you're found that's under your control at any time by any probation officer. You're also ordered to pay the court costs, and if you fail to do that, then the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion, if that doesn't collect it, then the court could permit you to do community service and give you credit for each hour you work, and a highly accept by the court each hour you work will reduce your judgment by that amount until paid in full. All right. Is there anything further, counsel?
Yes, sir.
You're remanded to custody.
May I approach you?
You may. right, case number 25 CR 46, State of Ohio versus Dustin Ray McCollum. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Jacob Wagner. Are you Dustin Ray McCollum?
Yes, Your Honor.
All right. Mr. McCollum has entered a plea of guilty to pandering and obscenity involving a minor, violation of section 2907.32 A5. Can't read my writing there. 5. A fourth degree felony. The matter was referred to the probation department for a pre-sentence report. The court has received that. They reviewed that. Of each of the attorneys had an opportunity to review a summary.
State has, Your Honor.
We have, sir.
All right, and Mr. King, has the victim of this offense been notified of the time, place, purpose of this hearing, the right to be heard?
Yes, Your Honor, and they've elected not to attend the hearing today.
All right. All right. Now, Ms. McCollum, as we discussed at the time of your plea, your conviction of this offense requires under law that you be designated as a Tier 2 sex offender registry. And what that means is that you'll be required to register in person with the sheriff of the county of residence for a period of 25 years. And that will be required to be registered in the county of residence within 3 days of your being there. And since your residence is here in Highland County, that would be at 130 Homestead Avenue at Hillsborough, Ohio, the location of the Justice Center. Now, you'll also be required to register in person with the sheriff of any county in which you may establish a place of education. If you're going to classes or enrolled in a college somewhere else in a different county, you have to register in that county. If you are working, including doing community service or volunteer work in another county, and you do that for more than 3 days consecutively or 14 days in a calendar year, then you'd be required to register there as well. So you could be required to register in as many as 3 different counties. If you're living in one county, working in another, and attending a place of education in another. Now, in the event that you were to move to another state or be employed in another state or go to a place of education in another state, then you would be required to register with the sheriff or other public official that is designated as the person or the office to monitor sex offender registrations. Now, you'll be required to verify every 180 days. So that means you will have to go in person. Can't do this online or by Zoom or phone. You have to do it in person. You'll have to report to the Sheriff's Department in person every 180 days. You can report 10 days prior to your 180-day date, no earlier than that. Now, if you are going to be gone from your residence of a county of residence for 7 days or more, say you're on a vacation or you visit a family or you may be hospitalized or something of that nature, you're required to provide the sheriff of your county of residence with your temporary lodging information, where you'll be and with the length of your stay. If you change your residence, you must report, or your place of education, you must report that proposed change at least 20 days prior to that occurring to the sheriff or sheriffs of the 2 counties in which, 1 or 2 counties, whether residence and or place of education. If you change employment, you may report that up to 3 days after you change, because you don't have to report until you've worked in a different location 3 days or more, or 14 days in the calendar year. But if it's 3 days or more, you have that 3-day grace period to do that. You're also required under federal law to report any international travel to your registering authorities at least 21 days prior to that date. Failure to do so could result in a criminal prosecution. You're also required to provide written notice within 3 days to any county or office where you're required to register any change in your vehicle information, email address, internet identifier, or telephone numbers that are either used by you or registered to you or used by you. And you must report that to the sheriff or sheriffs of the counties in which you are registered. Now, in the event that you fail to register as required or to verify your residence and or provide the notices required for changes in accordance with the statute, then under Chapter 2950 of the Higher Revised Code, you will be subject to being prosecuted for a felony and, if convicted, sentenced to a term of incarceration. All right, Mr. Wagner, if you approach, then I have signed this and filled out the bottom and the date. And there's you'll be required to sign this, Mr. McCollum, so it'll be put in the file to show that you were advised of these requirements.
May I approach, sir?
You may. All right, Mr. King, anything on behalf of the state regarding the matter of sentence?
Thank you, Your Honor. The state would ask that the court follow the joint recommendation and place the defendant on community control. I would note that the victim's representative has approved of this disposition. That's all. Thank you.
Mr. Wagner?
Yes, sir, Your Honor. In addressing the court here today, again, I thought about what to say, and I know some of the things I'm going to say is going to take me down a slippery slope, so I'm very careful how I articulate this. Dustin's a good young man, Your Honor, and I mean this respectfully to him. I think cognitively there's some things that don't register to the same level with myself or you, and I mean that respectfully to Dustin. That being said, though, Your Honor, Dustin is a very hard worker. He's been working at Seal Tight now for a year and a half, getting 40 hours a week. He's got insurance that covers his medication. Just yesterday he talked about his insurance helping him from a $10 a pill med to it costing now $1 a pill. As far as the facts of this case, and this is where I'm going to try to toe that line, Your Honor, I do think there is a gray area in some of these charges. Someone could disagree with me if they wanted, but I don't think this was a case where this is a grown man circling a playground, trying to pass out candy to little kids or going into the dark web, getting caught in a sting. I'm not justifying his conduct. This was someone that he either knew through school or through an acquaintance, through one of his siblings. They struck up a conversation throughout phone text, and it went where it should not have. Dustin knows morally, I think, when this was going down, what he was doing was improper. I don't think he knew or grasped the gravity of the situation, what could have happened in this case if it wasn't for the cooperation with the prosecution and the victim in this, which we're greatly appreciative of. That being said, Your Honor, as far as his family, I've known, not personally on this level, the McCollum family been in Hillsborough, I think, ever since I have. They're quality people. I know their contribution to this community. They keep him on a very short leash. I'm not sure Ms. Benson may be able to speak more to this, but when I spoke to Dustin, he's kind of asked me about his questions, what he can and cannot do. I think he may have called her too much. I'm not sure. I think he called her if he went to the grocery and took her a receipt, if he did something else. I don't think there's going to be any problem whatsoever, Your Honor, on keeping this young man on community control. With that being said, and I will finally be quiet, in any of these sex crimes cases, Your Honor, obviously the registration to me is the scarlet letter that I think is a punishment that never goes away. And I think that sets in this case. He's concerned about going to church with his family. I think his family's, even when they go to church and go out to eat for dinner or lunch afterwards, Dustin doesn't go, just out of fear of breaking your house arrest rules. So I think we have a young man, Your Honor, who's going to follow your letters or your rules to a T. With that being said, Your Honor, again, I'd like to apologize to the victim, and we thank the prosecution for making this offer, Your Honor.
Mr. McCollum, is there anything you would like to say?
Short and sweet.
I'm sorry for my actions, and I apologize to the victim and the victim's family, and I don't condone my actions, and I'm sorry for everything I've done, and I regret it every day.
Okay. Well, Mr. McCollum, the court takes very dim view of people who commit sex offenses and count on fingers, probably about 3 fingers or less of the number of sex offenders that have been convicted in this court since I've been judge that have not gone to prison. I'm going to add you to that list because I think that the circumstances of this case are unlikely to reoccur. I think as a product of somewhat of your immaturity and lack of understanding of the seriousness of the matter, and it was a situation where you were interested in a younger girl who was just a little bit underage, but unfortunately we see these kind of things happening with young people. Actually, we see them happening with older people because of the internet and phones and people and ease to take a photograph and then send it to somebody, and it just one of those things is technology can be a good thing, but there's one of those areas where it's not. But unfortunately, young people and other older people with less discretion or good judgment make these mistakes. It's not a situation of where we see where a person who's a purveyor of pornography or is a child abuser or anything of that nature. And so because of that, I'm going to grant your attorney and the state's request to place you on community control. And it is the order of the court that you be sentenced to a term of 3 years of community control under these conditions. You'll be supervised by the probation department. You'll be required to report to them when and as directed, conduct yourself in law-abiding manner at all times, obey all laws of all jurisdictions. You must keep them informed of your residence and place of employment at all times, may not change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. If you do, you must have that pass with you. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not permitted to purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapons of any type. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of a controlled substance that may have effects similar to those, unless you have a lawful prescription. You may also only possess an instrument, device, or thing that may be used to administer drugs or prepare them for administration if you have a lawful prescription. If you have a lawful prescription for either a device and or a substance, then you provide that to your supervising officer. Within 24 hours of receipt, you're to submit to drug testing when and as directed. You may not purchase, possess, use, or have in your control any kind of alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if otherwise lawful. Not to associate with anyone who has a criminal record, a member of a gang, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship with another without written permission. You must report any charge of contact with law enforcement or charge of violating the law or any conviction, arrest, or citation not later than the next business day after that occurs. Provide your supervising officer financial information and records so your ability to pay any fees or costs can be reviewed. You're referred by the probation department for an evaluation or assessment for any kind of treatment, therapy, counseling, training, or programming. You'll submit to that if there's any recommendation for programming You're to enroll in and successfully complete that. You're also to pay the court cost of this action. And you are not to have any contact with the victim or any members of her family while you're on community control. By being placed on community control rather than being sent to prison, you're deemed to have consented to a search without a warrant for your person, residence, vehicles owned by you or used by you, and any other property place that's under your control where you're found at any time, any officer of the probation department. There will be no fine imposed. The court costs are also a substantive order, and if you don't pay those, it would be a violation of your community control. But it also subjects you to having the clerk collect those through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then then the court could permit you to do community control in this county and give you credit for each hour you worked in an hourly rate set by the court, and each hour you worked would reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have violated these conditions, the probation department will file a written notice that with the court. There will be a hearing. You'll receive a copy of that allegation. You'll be entitled to have an attorney to represent you. And if the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and then send you to prison for a period between 6 and 18 months. And I believe in this case there would be mandatory post-release control supervision, wouldn't there?
That's correct, Your Honor.
All right. And so that means that after you've completed the prison term, you'll be supervised on post-release control for a period of up to 5 full years by the parole authority under the terms they set. And if during that period of time they've determined that you have failed to comply, then they would return you to prison. They could return you to prison to make you serve an additional period of up to 9 months and, for one or more violations, because that's the cap is half of your prison term, and the maximum term is 18 months, so the maximum could be up to 9 months. However, you committed a felony. Then, in addition, whatever sentence the judge in the new case could impose upon you, that judge is also authorized to sentence you for committing that offense under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in that new case. All right. Is there anything further, counsel?
There you go.
No, sir.
This completes your your case. You're no longer under the pretrial supervision conditions, which includes house arrest. You're no longer under house arrest. And Mr. Wagner, I'm not surprised that he didn't go to eat with his family after church, because that's what the rule says. So
I give him credit. He didn't do it.
Well, so you did what you're supposed to do, and that's a good thing. So, but when I say house arrest, that means directly to and from, and no other stops. Sometimes I explain to people it means you can't stop at the carry out and pick up a pack of gum, or you can't go out to eat, or you can't stop by, well, I used to say pool halls when I was a kid, but I don't know if there's any pool halls left anymore. But anyway, you did the right thing. See the probation department on your way out. Thank you.
Thank you, sir.
Donald Lee Holt.
Is that
Case number 25 CR 54. Excuse me. Excuse me. State of Ohio versus Donald L. Holt. Present on behalf of the state, prosecuting attorney Annika Collins and assistant prosecutor Adam King. Present on behalf of the defendant is attorney Danielle Witt. You are Donald L. Holt.
Yes, sir.
All right, Mr. Holt has entered a plea of guilty to tampering with evidence, a third-degree felony. The matter was referred to the probation department for a pre-sentence report, and I have received that and reviewed a summary. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
All right, Ms. Whitten.
Yes, Your Honor. We asked the court for community control and to follow the joint recommendation. While Mr. Holt did not meet the criteria for drug court, he is very willing to do everything it takes for his sobriety. He is enrolled in outpatient and attends outpatient 3 to 4 times a week. He definitely has an ongoing drug problem. I read in the PSI he started using marijuana at the age of 8, I believe. So it's very, very long standing, and he knows that he does definitely have a problem and wants to turn himself around.
Hey, Mr. Holt. Anything you'd like to say?
It was a mistake, Your Honor. I'm trying to do what I'm supposed to. I've been clean now for 2 years.
How long?
2 years. I moved to Texas and then I come back and
All right. Anything else you'd like to say?
no, sir.
All right. Well, you be seated. You order the court that you be and are hereby sentenced to a period of 3 years of community control under these conditions. You'll be supervised by the probation department. You'll be required to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. Report when and as directed. Be truthful in all statements you make to the probation department as well and answers you give them regarding questions they may ask you. You're to keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you do, you must have that pass with you in the other state. You're not permitted to enter upon the grounds of any correctional facility of any jurisdiction, nor may communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You may not, because of this conviction, purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or to do so would be in violation of both federal and state law for which you could be prosecuted, and if convicted, sentenced to a felony term of imprisonment. It's a condition not have any of those or any other weapons while you're under community control in this case. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance has effects similar to those. Nor may you have any instrument, device, or thing that may be used to administer or prepare them for administration unless you have a lawful prescription for both the controlled substance or drug of abuse as well as the device or equipment. You must provide copies of those within 24 hours of receipt to the probation department. You're to report or you're to submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any type of alcoholic beverage, nor may you be present in places where they're sold or being consumed, even as otherwise lawful. Not to associate with anyone who has a criminal record as a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense and violate these conditions. That applies to any family members that fall within that definition unless you were living with them immediately prior to the commission of this offense. You may not, after the date of this order, marry or establish cohabitation in a common law marriage type relationship with another without written permission. You shall report any contact with law enforcement, any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervised officer with financial information, records for your ability to pay any fees or costs to be reviewed. If the probation department refers you for any further evaluation or assessment for any kind of treatment, therapy, counseling, training, or educational programming, you'll submit to that. If there's a recommendation for programming, you're to enroll in and successfully complete that. You're to pay the court costs of this action. Are you working?
I'm going to get my job back now.
Okay. Well, you'll be required to do 400 hours community service at the rate of 20 hours per week for 20 consecutive weeks unless you are employed at least 20 hours a week, or you become a full-time student, or you have documentation from a physician or a prior disability finding that you're physically unable to do that work. You'll be required to successfully complete your substance use disorder treatment. That's abbreviated as SUD in your entry at the Recovery Council, which is abbreviated as TRC, and any recommended aftercare once you complete that. Now, by being placed on community control, rather than being sentenced to prison, you're deemed to have consented to a search of your person, your residence, or vehicles owned by you or used by you, or any other property or place where you're found or that's under your control at any time, any officer of the probation department. You'll sign a written acknowledgement and consent to that. The court costs are also a substantive order. If you don't pay the court costs, it'll be a violation of your conditions, but it would also subject you to having the clerk collect that through various means, including levy on bank accounts, wages, earnings, or other assets. Could also include a referral for collections, which would to collection agency, which would add 30% to what you owe for that service for the court. And if that doesn't collect it, then the court could allow you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of that with the court. There will be, you will get a copy of that. There will be a hearing. You'll be entitled to have an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and then sentence you to a term of between 9 and 36 months of incarceration in prison and fine you $10,000. If that happens, upon completion of that prison sentence, the Adult Parole Authority has the right, if they want to exercise it, to put you under post-release control for a period of up to 2 years. And if they do, you'll be supervised by the parole authority, by a parole officer on the term set by the parole authority. And if during that period of time they determine that you have not complied, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a cap or limit of half of whatever the prison term was for all violations. But if you committed a felony, in addition, whatever sentence the judge in the new case could impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentenced in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, that completes your community control or your case. You're no longer under pretrial supervision, including house arrest. You're under the new conditions. See the probation department on your way out. Thank you. Scott. Guilty to aggravated possession of methamphetamine, a 5th-degree felony. The court referred the matter for a pre-sentence report. And the court has reviewed that. Of each of the attorneys received a summary.
The state has, Your Honor.
To review.
I have, sir.
All right, Mr. King or Ms. Collins, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
All right, Mr. Wagner.
Yes, sir. Stand up, sir. Your Honor, again, this is one I inherited from Ms. Barger, so I was not involved in plea negotiations. My understanding is the community control, at least recommendation. I see him sitting here with a counselor, so it appears he's probably in counseling. I just ask the court to follow the recommendation, Your Honor.
Anything you'd like to say, Mr. McMurray?
No, it's on. Other than, I'm sorry. I mean, there's nothing else I could do. I was guilty, so,
All right, you can be seated. Sure, the court that you be sentenced to a term of 3 years of community control under these conditions. You'll be supervised by the probation department. Under these conditions, you obey all laws, all jurisdictions, conduct yourself in a law-abiding manner on time, report when and as directed. Be truthful in all statements you make to the probation department. Be required to keep them informed of your residence, place of employment at all times. May not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. You must have a copy of that with you when you're in the other state. You're not permitted to enter upon the grounds of any correctional facility of any jurisdiction nor may communicate with anyone who is an inmate in those facilities or attempt to communicate with them unless you have a written permission. Because of your conviction, Mr. McMurray, you are not permitted under either federal or state law to purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous weapon, or ordnance, and to do so would subject you to being prosecuted under both federal and state law for a felony. You're not permitted to have any of those or other weapons of any type while you're on community control in this case. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance or that has an effect similar to those or drugs of abuse, unless you have a valid prescription for that substance. You may not have any device or equipment that may be used to administer drugs, prepare them for administration, unless you have a lawful prescription for that as well. And if you do have prescriptions for either or both of those things, anytime you do, you must provide a copy of that within 24 hours of the receipt. You are submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may be present in places where they're sold or being consumed, even if that is otherwise lawful. You're not permitted to associate with anyone who has a criminal record, is a member of a gang or other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions unless you have a written permission from your supervising officer. And that applies to any family members that may fall within that definition, unless you were living with them immediately prior to the commission of this offense. You may not, after the date of this order, marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You'll provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If the probation department refers you to for an evaluation or assessment for any other type of programming, counseling, training, etc., beyond that order by the court, you'll submit to that. If there's a recommendation for programming, you're to enroll in and successfully complete that. You pay the court costs of this action and make payment arrangements to do that. You'll be required to successfully complete your substance use disorder residential treatment, and that's abbreviated as SUD in your order, as well as any aftercare at Recovery Council, which is abbreviated as TRC in the order. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any of the property places under your control or where you're found at any time, any officer of the probation department. Now, in the event that there's an allegation that you have failed to comply with these conditions, the probation department will file a written notice of that with the court. You'll get a copy. There will be a hearing in which you'll be entitled to have an attorney. If the outcome of that hearing is you fail to comply, then at that time the court could revoke the community control and sentence you to a term of incarceration between 6 and 12 months, fine you $2,500. If you're convicted of a new felony while under community control and sentenced to prison for that, then those sentences can be ordered to be served consecutively. If that occurs upon completion of that prison term, it's possible the adult parole authority would exercise the option that's granted to it under the law to put you under post-release control supervision for a period of up to 2 years. You'd be supervised under terms they set by a parole officer. If during that period of time they determine that you failed to comply, they could return you to prison to make you serve an additional period of up to, in this case, half of your prison term for one or more violations. But if you commit a new felony while on community control or on post-release control, then in addition to whatever sentences imposed in the new case, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. I forgot to indicate, but you're also to pay the court cost, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, or any other assets you may have, including referring it to a collection agency, in which case that would add 30% to the amount that you would owe for those court costs. Or the court could also allow you to do, if you don't have the means to pay, would allow you to do community service in this county and give you credit for each hour you work and and each shall your work or reduce your judgment by that amount, hourly rate until paid in full. All right, is there anything further from council?
No, Your Honor.
No, sir.
All right, so this completes your community control, your case, you're no longer under pretrial supervision, you're under community control. You'll see Officer Benson there on your way out for instructions. Thank you. All right, and see, you're on the video with Mr. Rogers. Oh, no. Case number 25, CR 73, State of Ohio versus Joseph N. Oliver. Present for the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Jacob Wagner, and you are Joseph N. Oliver.
Yes, Your Honor.
Mr. Oliver has entered a plea of guilty to failure to comply with the order or signal of a police officer, a third-degree felony. The matter was referred to the probation department for a pre-sentence report. The court has received that and reviewed the same. Each of the attorneys had the opportunity to review a summary.
State has your
We have, sir.
All right, Mr. King, anything on behalf of the state?
Only was containing the plea agreement, Your Honor.
Mr. Wagner?
Yeah, we asked the court to follow, stand up, Joseph. Follow the recommendation of the parties. Again, no one's in the courtroom, so I can not speak legalese. This guy turned a simple, probably what was going to be a minor misdemeanor traffic ticket into a third-degree felony. And I say that because I'm kind of getting on him. If you look at his record, he's got a disorderly conduct and then some traffic issues. The problem was when he took off from reading the discovery, this wasn't just, I went down a quarter of a mile a little too far, too fast. Like I said, this might have been tailor-made for type of a diversion or something of that nature. He just made a boneheaded decision. Like I said, he could have had a payable ticket. Now he's looking at a third-degree felony. He's in counseling, Judge. I think he'll complete it. I don't know if it's alcohol or not. When he was in my office, he wouldn't come clean with me as far as what the substance is. My guess, it's alcohol, Judge. But I think if he gets a grasp on that, we're never going to see him again.
Mr. Oliver, anything you'd like to say?
I'm just very disappointed in myself. I just hope for the best, that the counseling helps me and everything like that. And, that's it.
You're working full-time?
Yes, sir.
You may be seated. It's your the courts that you be and are hereby sentenced to a term of 3 years of community control and the supervision of the probation department under the following conditions. Obey all laws of all jurisdictions. Conduct yourself in law-abiding manner of times. Report when and as directed. You must be truthful on all statements you make to the probation department. You must keep them informed of your residence, place of employment at all times. May not change either without prior written permission. You may not leave the state of Ohio at any time without prior written permission, and if you do, you must have that pass with you when you are in the other state. You're not permitted to enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not permitted to purchase, possess, own, use, or have under control any firearm, ammunition, dangerous ordnance, or weapon of any type. You're not permitted to purchase, possess, use, or have under control any controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to those or drugs of abuse, nor may you have any instrument, device, or thing that may be used to administer or prepare those for administration unless you have a lawful prescription both for the substance as well as the device. You must provide a copy of that within 24 hours of receipt of probation. You're to submit to drug testing when and as directed. You may not purchase, possess, own, or use, or have under your control any alcoholic beverage, or nor may be present in the places where those are sold or being consumed, even if otherwise lawful. Not to associate with anyone who has a criminal record as a member of a gang, or any person who could in the future influence you to commit a criminal offense or to violate these conditions, unless approved in writing by your supervising officer. Advise any family members that may fall within that definition, unless you are living with them immediately before the commission of this offense. You may not, after the date of this order, marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees or costs can be reviewed. You're referred by the probation department for any evaluation assessment for further treatment, therapy, counseling, training, and programming beyond that ordered by the court. You'll submit to that, and if there's a recommendation for programming, you're to enroll and successfully complete that. Pay the court costs of this action and make payment arrangements to do so with the clerk. You'll be required to successfully complete your substance use disorder treatment, which is abbreviated as SUD in your entry, and aftercare at TRC with the Recovery Council. Now, by being placed on community control, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property places under your control, or where you're found by any officer of the probation department. There'll be no fine imposed. Now, I think this does require a suspension of your driving privileges for 3 years. And so those are suspended commencing today. The court can grant you limited driving privileges if you're otherwise legal to drive. You have proof of insurance. The court will give you limited driving privileges while that suspension is in place. Now, but only for this court. I can't grant it if there's any other court that's involved. You have to get that permission from them. You're also ordered to pay the court cost as a substantive order, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. The clerk could also refer it to your collection agency, and that would add 30% to what you would owe if that occurred. If that doesn't collect it, the court could permit you at your request to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. And each hour you work will reduce your judgment by the amount until paid in full. Now, in the event that the probation department feels that you have failed to comply, they will file a written allegation of that with the court, give you a copy. If the outcome of that, you're entitled to have a hearing, an attorney. There will be a hearing. You'll be entitled to have an attorney at that hearing. And if the outcome of that hearing is that you failed to comply, then at that time the court will revoke your community control and sentence you to between 9 and 36 months in prison and fine you $10,000. If that happens, once you complete your prison term, it is mandatory. And I accidentally marked that out. I marked out the wrong part. It is mandatory. And you'll be supervised for a period of, let's see, at least 1 year, but not up more than 3 years. Under the term set by the Adult Parole Authority. And if they determine that you have failed to comply, they could return you to prison to make you serve an additional period of up to 9 months for any one violation, but there's a capital limit of half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence a judge in a new case could impose upon you, that judge is also authorized to sentence you for committing that offense under post-release control in this case to an additional period of 1 year or whatever time's left on that period of post-release control, whichever is greater. If that occurs, then that sentence would be ordered to be served consecutively to sentencing in the case. And I have, for purpose of the record, made a note on the entry where I'd scratched out mandatory. On one half I said, yes, it is mandatory. On the other side I say this applies. I did circle the 1 year, but not more than 3 years, so that's clear for the record. All right. Anything further from counsel?
No, Your Honor.
No, sir.
All right. This completes your case, Mr. Oliver. You're no longer under pretrial supervision or house arrest. See Officer Benson on the way out.
Thank you, Your Honor.
Thank you.
All right.
Good luck, man.
All right. Are you Dylan Rogers appearing there from the institution?
Yes, sir. That's me.
All right. This is case number 24 CR 48, still State of Ohio versus Dylan Rogers. Mr. Rogers was convicted by entry filed on May the 7th, 2024 for various offenses. I believe there were both drug offenses and also receiving stolen property in counts 1 and 2. Count 3 was trafficking of marijuana, and count 11 was also received. So actually 3 of the 4 were received. Mr. Rogers filed this motion pro se. The state's represented by Assistant Prosecutor King. Mr. King, had the victims of the offenses been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, they have, Your Honor. Well, the victims of counts 1 and 2 have been notified. They're not present this morning. We weren't able to make contact with the victim of count 11.
All right. All right, I don't know what that was. Can you hear me okay? No, you can't. I can hear myself. Mr. Rogers, can you hear me?
Yes, sir.
Is there somebody in the room there that could fix your mic? So you don't have all that reverberation? I think it turned on another computer. You hear me?
Yes.
All right, we're going to have to get some technical help here. If that's possible.
No, we can't hear you.
I don't know where Ben is. Call the bridge. Tell him we're going to have to do this all over. Call the bridge. We've got reverberation both ways. And there's nobody there. Tell him we're going to talk to this. I'm going to disconnect Mr. Rogers and try to call back in. And if we can't get this established as a good connection, we're going to have to reschedule this.
My case management is
All right. Well, while we're doing that, we'll just go to Mr. Rogers or Richards. All right, this is case number 25 CR 93, State of Ohio versus John E. Richards. Oh, wait a minute. Not there yet. Didn't let him in. All right, are you John E. Richards appearing there from the jail?
There you are. Yes.
All right, well, this is case number 25 CR 93, State of Ohio versus John E. Richards. This is a pretrial being conducted by Zoom from the jail. Ms. Hapner, the defendant's attorney, is present in the courtroom, as well as Assistant Prosecutor King. The matter that Mr. Richards is indicted for burglary and theft from a person of protected class, and Mr. King, as the alleged victim or victims of this offense, been notified of time, place, and purpose of this hearing.
Yes, Your Honor. They've elected not to attend the hearing this morning.
All right. Final pretrial in this matter is set for July 16 and trial set for August 25. I see the state's provided discovery, and you've received that, Ms. Hapner?
I have, yes.
All right. Your discovery will be due by the final pretrial then. Do you anticipate any pretrial motions?
Not this time.
And has there been a written plea offer provided yet?
Yes, I have received that. However, I have not yet had a chance to discuss that with Mr. Richards.
Okay. All right. Are there any other matters then that need to be discussed in this matter?
There you are.
There you go.
All right. Your attorney will be in touch with you, Mr. Richards. We'll have your final pretrial in 2 weeks. Thank you. Mr. Rogers, can you hear me?
Yes, sir. I can hear you now.
All right. Can you see me?
Yes, I can see you.
Is your screen going all green and stuff? Mine is.
It has red splotches in it, but I can.
All right. Well, hopefully we can get through this.
To address, we do have a ticket in for it.
Well, you know, as easy as the Zoom technology is, the state of Ohio insists on making conferences with individual institutions as difficult as possible. And if we could just do a Zoom, it would matter. It would make it a lot easier. But unfortunately, we have to go through the bridge and then through the institution, down to you and your caseworker, and it's just a mess. But that's the state. All right. So when we stopped, I believe I'd indicated that Mr. Rogers received a sentence of 59 months. The victims have been notified are not present. So is there anything you would like to say on your own behalf regarding the motion you filed, Mr. Rogers?
Yes, sir. I'd like to say that I'm ashamed of the reputation I've made in the community, that I've been taking this time to work on bettering myself. I've been going to college to be a drug counselor in the future. And I'd like to thank you for seeing me here today, and thank you for taking my request in consideration. That's it.
All right. Mr. King, is there anything from the state?
The state has no objection to the motion, Your Honor. This was agreed upon at the time the defendant entered his plea of guilty, and the victims also approved of this at that time. That's all then.
All right. Well, Mr. Rogers, I am going to grant your motion for judicial release. It'll be effective on the 15th of July because one of the conditions is going to be that you successfully complete the STAR program, and the bed for that is not available till July 16th. So on the 15th of July, you're going to be released to the custody of the Highland County Sheriff and brought back here. Now, the conditions of your community control and judicial release are that you be under supervision by the probation department for a period of 3 years, that you are required to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, be truthful in all statements you make to the probation department, you report when and as directed, keep them informed of your residence, place, and employment at all times. You may not change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. You're not permitted, once you're released from STAR, to enter upon the grounds of any correctional facility of any jurisdiction, nor may you communicate with anyone as an inmate in any of those facilities. You're not permitted, because of your conviction, to purchase, possess, own, use, or have under control any firearm, ammunition, or dangerous ordnance. And if you did, that would subject you to being prosecuted for a felony under both federal and state law. You're not permitted to have any of those items or any other weapons of any type while on community control in this case. You're not to purchase, possess, use, or have under your control any alcoholic beverage, nor may be present in places where they're sold or being consumed, even if it's otherwise lawful. You may not, I'm sorry, you are not permitted, Now, you're not permitted to have any controlled substance, drug abuse, or any instrument, device, or thing that may be used to administer those or prepare them for administration unless you have a lawful prescription. You must provide a copy of that within 24 hours to receipt. You're to submit drug testing when as directed. You're not to associate with any co-defendant in this case. I believe that was your wife. I believe you may, I don't know when's the last time you saw her, but you're not to have any contact with her. Nor are you any other person that has a criminal record, a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions. You may not, after the date of disorder, marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by probation for an evaluation or assessment for any further treatment, therapy, counseling, training, or other educational programming, you're to submit to that. If there's a recommendation for programming, you must enroll in and successfully complete that. You'll be required to pay the court costs to make payment arrangements with the clerk to do that. You'll be required to do 400 hours community service at the rate of 20 hours a week for 20 consecutive weeks, unless you're employed at least 20 hours a week, a full-time student, or you have documentation from the physician of prior disability finding you're not physically able to do that. You'll be required to make restitution of $1,019.34 to victim 2, $762.49 to victim 1. That's joint several with your co-defendant, Caitlin Rogers. Now, you're to be required to successfully complete the STAR program and recommended aftercare. And that means, Mr. Rogers, you must complete the STAR program completely, not 85% or 90%, 100%. If you fail to comply with any of these conditions, then the probation department will file a written notice of that, alleging that with the court. You'll get a copy. There will be a hearing in which you'll be entitled to have an attorney. The outcome of that is that you have failed to comply, then the court could return you to prison to serve the remainder of your term. And if you're convicted of another felony offense and sentenced to a term of incarceration on that offense, that term could be ordered to be served consecutive to this sentence. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your vehicles, of your person, your residence, vehicles owned by you or used by you, or any other property or place where you're found, whether it's under your control at any time, any officer of the probation department. Also, the restitution is to be made through the Highland County Victim Witness Restitution account, and you'll pay any fees associated with that. All right, so we will notify the institution and the sheriff. They'll be there, and STAR. They'll be there to pick you up at the institution on the 15th, and you'll stay in Highland County Jail overnight, and then be conveyed on the 16th to STAR. Do you have any questions, Mr. Rogers?
No, sir. I understand.
All right. Thank you.
Thank you.
forgot, what are the case numbers?
There's 4.
All right. This is State of Ohio versus Michael Robertson. There are 4 cases. Mr. Robertson filed a motion for sealing of his record. The state filed, state's represented by Adam King. The state did file a written objection, and the court reviewed that and determined that Mr. Robertson is not eligible for sealing of his record. He called the court yesterday, asked if he needed to attend. He's not present, and he was told by the court staff, by direction, that it did appear he was not eligible unless he had information that would show that he was. The court was going to deny the motion, and if he did not want to attend, that was up to him. So he did not attend, so motion will be denied at his cost. All righty, that's it for this morning. All righty. Case number 25-088. State of Ohio versus Kendra L. Halbert. Are you Kendra L. Halbert appearing there from ORW?
Yes, Your Honor.
All right. This is a pre-trial being conducted by video since Ms. Halbert is incarcerated. Her attorney is President of Courtroom Danielle Witt. Present on behalf of the state is Assistant Prosecutor King. Ms. Halbert is charged with tampering with evidence and aggravated possession of methamphetamine. This is the first pretrial, final pretrial set for July 16, and the trial date is set for August 14. All right, I see that the state has provided discovery, and you've received that, Ms. Witt.
Yes, Your Honor.
All right, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
No, none at this time.
All right. Has there been a written plea offer provided?
There has.
Is your client aware of it?
She is.
All right. Are there any other matters need to be discussed for this case?
No, Your Honor.
Your Honor, so will she be brought back for the 16th?
Yes, I was just making a note of that. The 16th will be a Wednesday, so we'll have her brought back on the 14th.
Okay.
And I'll have Ms. Boyer do an entry Monday. All right, so we'll be bringing you down on the 14th, Ms. Halbert, so you'll be able to talk to your attorney in person before your final pretrial on the 16th. It'll probably be in the afternoon of the 14th.
Okay.
All right. All right, anything further?
No, Your Honor.
No, Your
All
Honor.
right.
Thank you.
Thank you. And what's our next case? All right, this is case number 25 CR 67, State of Ohio versus Todd Richard Ray. It's Ray, right?
Yes, sir.
Jr. Mr. Ray is appearing by Zoom from the probation office. His attorney is Danielle Witt. Appearing on behalf of the state is prosecuting attorney Collins. This matter is set for a plea hearing. And Ms. Witt, are you and your client both in agreement this matter can be conducted by Zoom rather than actual in-person appearance in the courtroom?
Yes, we are.
You're all right with that, Mr. Ray?
What was that, sir?
You're all right with having this hearing by Zoom rather than coming into court and sitting here in front of me?
Oh, yeah, absolutely. Okay. Yeah, absolutely.
All right. Well, if since you're not next to your attorney in court, if you have any questions while we're doing this, you let me know, or if there's something you would like to speak with her about, let me know. And I'll put you and your attorney onto a breakout room. It'll be just the two of you on the screen. No one else will be able to see you or hear you during that discussion, okay? All right. Now, Mr. Ray, you were charged by indictment back in May of aggravated possession of methamphetamine, a 5th-degree felony. The matter is set for trial in a couple of weeks, I believe. And I have been provided a plea agreement form. I'm going to hold the first page up to the camera that shows the name of the case, your name on it, the case number, plea of guilty, and ask if you recognize that document.
Yep. Yes, sir.
All right. On page 3, there's a sentence that reads, I enter this plea voluntarily. Right below that is a line for signature defendant, and it appears to be a signature of Todd Ray Jr. And is that your signature?
Yeah, I signed it.
And when did you sign this?
I signed it the last time I was here and signed it with Miss Witt.
All right. When you signed it, did you understand that's an agreement to plead guilty, meaning there won't be a trial, and the next step would be a sentencing hearing?
Yes, for drug court or something, referral to drug court.
All right. Well, we'll get to that in a minute, but you understood that that's what it was, a plea agreement?
Yes, sir.
All right. And so that means there won't be a trial. The next step then would be deciding what to do with your case. You understand that?
Yes, sir.
All right. And before you signed it, did you go over it with Ms. Witt and have her explain things to you and answer any questions you had?
Absolutely, Your Honor.
And are you satisfied that you had enough time to fully consider the matter before you make this decision?
Yes, sir.
And since there's been a few days that have passed since you signed it, are you still wanting to go forward with this?
I'm a little bit confused, honestly, about the drug court.
All right. And what is your confusion?
Well, I mean, I don't understand what it is actually. I mean, okay. I know that.
Well, drug court is a program that the court operates for people that are on community control who have a high risk of relapsing or continuing to use drugs and to commit criminal offenses. It's an intensive program. And that will be explained to you in full by the people that run the program for the court if you go forward. And so what happens is you're referred to that program. And drug court's voluntary. You don't have to do it. It's up to you. I don't order people to go into drug court because people have to be in drug court because they want to be, not because they have to be. And so that will all be explained to you at that time.
Okay.
So she'll answer those questions for you, okay?
All right, sir.
All right. Now, the document states that you understand that the charge against you is aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code, 5th-degree felony, and that you could face a term of incarceration between 6 and 12 months and a fine of $2,500 if convicted. You understand that?
Yeah.
And are you facing any felony charges anywhere else?
Absolutely not, sir.
Are you on probation, community control, parole, or post-release control for a felony?
Just what you gave me.
The pretrial supervision in this case?
Yes, sir.
All right, but other than that, you're not on any other kind of supervision?
No, sir.
All right. Now, under the law, if you should be convicted of this offense, and if you should ever be ordered to serve a prison term. Upon completion of that term, the adult parole authority does have the right to put you under post-release control for up to 2 years under the terms that they set, meaning to be supervised by a parole officer. And if during that period of time you violated those, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you're convicted of a new felony, then they could sentence you in that new case to an additional period of time for committing that offense while post-release control in this case, and that would be a 1 year or whatever time is left on the post-release control in this case, whichever is more, and if that occurred, that would have to be served consecutively to the sentence in that new case. Do you understand that?
A little bit, but I have no desire to go back out and get in any more trouble than what I'm already in. I mean,
Okay. Well, I mean, that's good, but I just need to ask you these questions. All right.
Yes, sir.
Do you have any questions then? I'm just having to explain the worst case scenario for you. Okay?
Yeah, and I'm sitting here swallowing it all in.
All right, good. Now, under the law, I'm not required to sentence you to prison for this offense if you plead guilty. I can order you under what's to be sentenced to what's called community control or probation. That's what most people understand.
Yeah.
And that means you could be under the supervision of the probation department for a period of up to 5 years on a term set by the court. And the drug court docket operates as a part of that, and that would be different conditions, but it would still be community control.
Yeah.
If during that period of time the probation department thought that you were not complying with those conditions, they could file a written notice of that with the court, give you a copy. There would be a hearing, and you would have the right to have an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time you could be sentenced to 6 to 12 months of incarceration and fined $2,500. And if you committed a new felony while on community control and were sentenced to a prison term in that case, that sentence could be ordered to be served consecutively to the sentence in this case. Do you understand that?
Yes, sir.
All right, now the charge in this case indicates that on or about April 2, 2025 in Highland County, Ohio, you knowingly possessed, obtained, possessed, or used a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge. Now, Mr. Ray, do you understand what it is you've been charged with, what the state said you did, when, where, how they alleged that you did it?
Yeah, I made a mistake.
All right. But you understand the charge?
Yeah.
All right.
Yes, sir.
Have you discussed the charge, the evidence in the case, the legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, we have.
Are you satisfied with her advice and competence in this matter?
She's been she's given me some pretty decent advice, yeah.
Okay. Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty, Mr. Ray?
No.
Now, on page 2, it states that defendant will enter plea guilty to the indictment, state and defense jointly recommend community control and a referral to drug court. Is that your understanding of the agreement?
Yeah, I'm trying to get this case over with, honestly.
Okay. Well, has anyone promised you anything other than that to get you to plead guilty here today?
No.
All right. Now, you need to understand, Mr. Ray, that under the law, the recommendation on the sentence isn't binding on the judge. So if you plead guilty, the court doesn't have to follow the recommendation. The court could decide after all the information was presented that that's not the correct outcome and that there should be a sentence of incarceration and or a fine. You understand that?
Yeah, basically it's up to you and what you do to me.
That's exactly right. Now, and again, the referral to drug court is just for you to be interviewed to determine if you would like to apply to be part of that program. Because again, we won't make you do that if you don't want to. It is up to you. But the drug court officer and coordinator will explain that to you and what it entails before you make that decision. All right? You understand that?
Yes.
Okay. Now, Mr. Ray, do you hold any type of license or certification from a state governmental agency that regulates any occupation in the state of Ohio? Something like nursing or a home care assistant or physical therapist or vet aid or anything like that?
No, I'm not no licensed contractor. No, I'm not licensed to like doing that kind of stuff. No, but I did go get checked into the REACH program like I was asked, and pretty much, know that I need to get into some kind of treatment. So I did go do the REACH program.
Well, it's not that. I mean, this is for, because in certain professions, if a person that holds a license gets convicted, the licensing agency has to be notified.
Okay, yeah.
Now, you have certain constitutional rights you must understand, Mr. Ray, before I can accept your plea. First, you have a right to have counsel, and Ms. Witt was appointed to represent you since you did not have the funds to hire your own attorney. Her appointment wasn't for the purpose of simply working the case out, but was to provide any defense that may be available to you under the law that you would like her to. So if you decided you didn't want to plead guilty, you wanted to fight the charge, she would continue to represent you in doing that, including a trial if that's what you wanted. Do you understand that?
Yes.
Now, under the Constitution, Mr. Ray, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of people that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence is presented, and they are instructed on the law by the judge. And then that jury of 12 then has to decide whether the state proved your guilt by proof beyond a reasonable doubt, and that verdict must be guilty, must be unanimous, meaning all 12 would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, in which case you would have a court or bench trial, meaning the judge would be the one that would hear the evidence instead of a jury. The judge would apply the law. The judge would decide whether or not the state proves your guilt. Do you understand that?
Yeah, honestly, I'd like to get it over with today.
Well, you have to be patient because we can't get it over all today. This is the first step only. Today is for a plea, and then if you plead guilty, then there's going to be about 30 days for the probation department to meet with you and give me a report. Okay?
Okay.
Now, under the Constitution, well, again, you understand you have a right to a jury trial or a court trial as you choose.
Yes, sir.
All right. Under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. That means that the witnesses against you have to come into the court, testify in front of you, your attorney, and anyone else that's observing. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that could help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, you request the court issues a court order called subpoena, and that forces those people to come into court to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Under the Constitution, the laws of the state, Mr. Ray, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever testify. The prosecutor can, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can even talk about that, with one exception. If there is a jury trial and you do not testify, the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of this crime. In fact, under the law, you don't have to put on any defense in your own behalf. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt, but proof beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally entered a plea of not guilty. Not guilty plea denies allegation in the indictment, denies you've committed any crime, and it exercises or invokes all the rights I've just described. If you change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, and that you committed that crime. And that plea would waive or give up all the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. Without exception, your plea of guilty waives gives up your right to a jury or court trial. Waives gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to come into court and testify on your behalf, the same as the state. It waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you may have had up until this point in the case. Now, if you are sentenced to the maximum sentence at some point, or under other limited circumstances, you may be able to file an appeal. Any appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes. Now, what about no contest? Now, no contest pleas out of the question?
No contest plea can only be entered with the consent of the court, which is seldom done in a felony case unless there's an exceptional legal reason for doing it, which in this case I can't see that there would be any.
Okay.
Okay. Now, you understand all those things I've just explained to you then?
Yes, sir.
All right. And are you a U.S. citizen?
Yes, sir.
And are you entering into this agreement today and pleading guilty today voluntarily?
Yes, sir.
All right. Is there anything you need to speak with Ms. Witt about before we go any further?
If she wants to meet in her office later, we can, or we can do it now.
I mean, do you have any questions that you need to ask her before we go any further?
No, not really.
Okay. If you do, I'll put you into the breakout room. But only if you need to know something about this agreement. I mean, she'll undoubtedly speak with you before your sentencing. But anything else?
No.
All right. So then is it your decision to go forward here today and enter this plea of guilty pursuant to the terms of this agreement?
I made a mistake. It was guilty, so yeah, I'm going to go ahead and
all right.
plead guilty.
So then as to the charge, which alleges that on or about April 2, 2025 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code. Charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible term of incarceration of 6 to 12 months, fine of $2,500. How do you plead?
Guilty.
All right. The court finds on this day in open court, defendant is advised of all of his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal 11. Plea is accepted, ordered filed. Defendant is found guilty of the offense. The court will order that a pre-sentence report be made. That shall include an assessment for substance abuse disorder and or mental health. The case will be referred to the drug court docket to determine if you meet the criteria, because you do have to meet certain qualifications to be considered for that, in addition to wanting to be in the program. So that will be part of that process. So you'll meet with the drug court coordinator. Bond will be continued, and you'll be sentenced in person here at the courtroom on August the 6th, 2025 at 9 a.m.
August the 6th at 9 a.m.?
Yes. And before you leave, see Officer Benson, and she'll make the appointment for you to meet the officer that will be preparing the pre-sentence report. All right. Is there anything further from counsel?
No, sir.
All right. Thank you.